Okay, so welcome everyone, distinguished speakers, panelists, participants. Our today's panel is going to be on the role of the national judiciary in the enforcement of climate change mitigation and adaptation. My name is Javid Gadirov. I'm assistant professor and associate dean at the School of Law of Adda University in Azerbaijan, and I'm very honored to be with everyone. Let me introduce the participants of today's panel. So we're going to have Professor Sadiga Mehdiyeva, who is also a faculty member at the Adda University, who I think specializes on environmental law, among other things, and has worked in this area and has a keen interest in it. And we have another faculty member from Adda University, and that's Professor Labardini, who agrees to, and Ambassador Labardini, if I may. Besides our speakers from Adda University, we also have Dr. Ramin Gurbanov, who is a judge at Baku Court of Appeals, and former president of the European Commission for the Efficiency of Justice. Thanks for joining us, Dr. Gurbanov. We also have another judge today on the panel, and that's Judge Günel Sevdimaliyevadv from Baku Administrative Court. Welcome, Günel. And we have also two of our prosecutors, and joining us, that's Prosecutor Bakhtiyar Mirzayev from Prosecutor-General's Office, Department of Non-Criminal Proceedings, and Prosecutor Kamran Aghayev, who is also from the Department of Non-Criminal Proceedings. And I say welcome everyone. Let's perhaps move on to the main topic of the discussion. So I will introduce the main three focus questions that we are going to talk about, and then I will proceed to my own part, and perhaps Sadiga Khan will also take 1 minute of our time before I move on to the substantive discussions and we launch them. So our main topic, as I said, was the role of the national judiciary in the enforcement of climate change mitigation and adaptation. So we are going to mostly focus on three questions, and first one is going to be the proper role of the judiciary and judicial branch in the enforcement of climate change mitigation measures, such as adjudicating on government carbon emission regulations, for example. The next question is going to be on the approach of the courts to claims that arise from climate change adaptation measures, more or less, and what is the role of fundamental human rights in this from this angle. And finally, we are going to talk about what measures should be endorsed by courts to enforce liability for breaches of climate mitigation and adaptation measures by private parties, in particular, the corporate responsibility for environmental damage. So that would be the three, the three focus questions we will try to cover. So before we move on to the first question, where I will make my presentation, short presentation on justiciability of climate change in Azerbaijan legal system, and pass the floor then to Dr. Gurbanov. I think Sadiga Khanum also wanted to have 1 minute from the initial timing. Sadiga Khanum,
okay,
welcome.
Thank you. Thank you for having me here. Thank you for introduction. I just want to briefly mention that climate-related cases are increasingly shaping legal policy responses to this global challenge, and those disputes generally fall into two main categories. They are international climate rights cases, also domestic climate rights cases. During our discussions, we will review some cases and we'll refer to that cases. And also I want to mention that there is a very strong trend in climate litigation. the fact that most decisions are made by national courts. And very often those decisions are grounded in constitutional and human rights principle, while we traditionally observe that international law influencing national law, climate disputes are unique. So here we can see that how decisions made by national courts are driving the evolution of international climate law. So I think this point is very important. Also, I want to draw your attention to the numbers. According to the Univ, as of 2022, courts in 65 jurisdictions have handled almost more than 2,000 climate-related lawsuits. So number of climate cases, number of climate litigations are steadily increasing. That's all that I wanted to mention. Thank you for your attention.
Thank you, Sadiga for giving this background. So, if nobody objects, I will move to the first focused question, and myself as a first speaker for this, and the question on the justiciability of climate change, climate change in domestic judicial system. So it is again another background observation that, of course, this not only in domestic courts but international courts also enter into the adjudication of climate-related disputes in the recent years, and we can say that international law in general enters into the judicial stage of, so to speak, climate change, and we can see a rising number of cases in various courts, and in particular one court, which is the European Court of Human Rights. So Azerbaijan is a party to the European Convention on Human Rights. It's the decisions. It has a direct legal effect in Azerbaijani legal system, and moreover, our courts are expected to interpret the convention and apply it in the light of the case law of the European Court of Human Rights. And in the recent years, we have groundbreaking, basically, judgments. Such as the Swiss judgment, but there are other pending cases as well from Italy, I see, from Austria, Norway, Germany, and many other states. So we can see that my main argument or observation about this is that Azerbaijani constitutionalism is still more or less incipient. And I argue or suggest basically that the issue of climate change mitigation should not be enforceable by courts in incipient constitutionalist settings, such as in Azerbaijan, and is better left to democratically accountable political branches of government for separation of powers reasons, more or less. So that's my general argument. Of course, feel free to tear it apart, but I think that engagement of courts on national system, on national level, will have some undesirable consequences for constitutionalism in Azerbaijan, because the courts will have to assume new, uncomfortable, basically for them, role in separation of powers framework of Azerbaijani constitution, and so the litigation of the sort. Such as, for example, the case of Klima Seniorinen case versus Switzerland, will require our courts to basically weaken, first of all, at least standing requirements and increase the judicial power. And in the judgment, for example, we can see that in climate change, so for example, the European Court famously ruled actually that Switzerland didn't comply with its obligations by not providing for general measures adequate. There were lacunae in Swiss carbon emission targets and so on. But we can see that in these types of cases, the injury becomes less personalized. So the requirement of standing that there should be an injury which is personalized, is weakened. the causal link between injury and government action is attenuated, and judicial remedies may require courts basically to engage in monitoring decisions which are within the discretion of other branches, such as executive and legislative branches. So, in other words, this can undermine the legitimacy of the courts because they shouldn't be deciding what is the correct balance between development goals and, for example, and environmental protections. And if they start supervising other branches, the legitimacy and authority will be undermined. Instead, we should focus on enforcement. They should focus on enforcement of other fundamental rights, such as freedom of expression and so on. Okay, I think I have already breached my time requirements, so I will pass the floor to Judge Dr. Ramin Gurbanov, and to hear his thoughts on the matter. Please, Judge, welcome.
Thank you very much, dear ladies and gentlemen, dear participants. Taking this opportunity, I would like to express my gratitude for invitation to participate in such important event organized by the other university in close cooperation with the Cambridge University. Today's meeting is being held within the framework of the 29th Conference of Parties of the United Nations Framework Convention on Climate Change. And we are proud that Azerbaijan today is hosting such an important event. As you know, in the recent years, the climate change has come to the forefront of the public consciousness, and therefore we have seen increased global urgency and public awareness regarding this issue. And this awareness has led to the advent of a new and ever-evolving field of environmental law relating to mitigating climate change risks and climate change litigation. I would like to share with you my observations from theoretical and practical sides. So, international community is starting to be bound by the general international law to act against the climate change. The preservation of sustainable climatic balances and the need to adapt to the inevitable ongoing climate alterations represent general and mandatory international obligation of each state. A large portion of what we refer to when we speak about international climate law has been adopted under the auspices of the Framework Convention, the annual conferences of the parties, with the Kyoto Protocol, with the Paris Agreement, which is standing out as the perhaps most well-known examples. I would like to refer to the Article 3 of the Framework Convention. The parties should protect the climate system for the benefit of the present and future generation of humankind on the basis of equity and in accordance with their common but differentiated responsibilities and respected capabilities. As we see, this principle, especially in the light of different national circumstances, is an expression of equity concerns raised by the climate change challenges and the erga omnes duties of each state to protect the environment, to mitigate and manage the climate change. In recent years, have seen a strong growth of the use of law to address climate change worldwide. Until recently, international law has had only modest success in addressing climate change, but recent years have seen a shift, including the expansion of climate change issues into the other areas of international law, such as environmental or ecological law. Climate change is a major issue in environmental law. Environmental law focuses on a wide range of topics relevant to climate change, such as air quality laws, water quality, waste management, protection of endangered species. These laws are designed to minimize the environmental impact of human activities and prevent environmental contamination. I would like to say that violation of environmental law directly and indirectly influence the climate change in all countries. Courts and tribunals all around the world have come to play an increasingly central role for climate change measures, including in cases in domestic courts where parties rely on the provisions of the Paris Agreement. And I would like to say that the majority, the increase in the number of cases worldwide was exactly increased after the signing this Paris Agreement. So Azerbaijan court system is also not an exception. So generally speaking, climate change disputes remain largely unresolved worldwide by political action, and citizens are therefore seeking relief in courts. But they faced with different challenges: traditional standing, justiciability, evidence rules hinder access to climate justice and making it uncertain and potentially expensive for plaintiffs. I would like to draw your attention to the human rights context. Climate change impacts fundamental rights with increasing and irreversible effects. That's why in the recent years, we observe that there is a growing trend in people and organizations using Europe's unparalleled system for protecting human rights to help tackle environmental problems. There are many continuous debates on the issue of human rights in the context of the climate crisis, especially within the European Convention on Human Rights. Azerbaijan Republic is also a part of this convention, and despite the fact that in the convention there is no any direct regulation on the right to a healthy environment, the European Court pays special attention to this issue in the context of other rights reflected in the Convention and delivered more than 300 environment-related judgments. For example, for the first time, the European Court in 1994, in the case Lopez Ostra against Spain, ruled that the Spanish state was alleged in violation of the right to respect for home, private, and family life as a result of the pollution caused by the waste treatment facility. What I would like to raise here, that this is a combination of the right to a healthy environment and the right to respect for private life, home and family life, access to environmental information. And so it means it was a violation of Article 3, Article 8, and plus in the other judgments relating to the Swiss government, the court also ruled that this is also can be considered as a violation of Article 6 as a right to fair trial, including the access to justice. When we come to the Azerbaijan experience, I would like to say that in Azerbaijan justice systems, there are a wide variety of regulations in the protection of human rights in the field of environment and climate change disputes, starting from constitution, following the special chapters in the criminal code, code of administrative infringements, and specialized laws and bylaws. In Azerbaijan court system, the climate change issue are justiciable in administrative court. In general, if adequate environmental conditions due to the climate change compromise the human rights, governments are liable to be sued, and the administrative cases involve the review of administrative decision-making by central and local governments. When it comes to the private law cases, the general jurisdiction courts are considering civil cases, involve disputes about negligence, nuisance, public trust, fraud, and consumer protection. But we face with the difficulties to prove that the harm the plaintiff incurred was directly attributable to the defendant's action. When it comes to the criminal and administrative infringement cases, especially in the field of the ecological crimes, which have direct influence on the climate change, it's important to indicate that the ecological crimes are characterized by the high level of latency and causal relationship between illegal act and caused damages. That's why the prosecutors play a key role in addressing challenges in criminal, administrative, and civil proceedings in environmental cases. Finalizing my speech, I would like to say that the climate change litigation should be considered in the courts in the context of other human rights and other fields of law, such as ecological law, criminal law, and etc. Thank you very much.
Thank you, Professor. Thank you, Judge Dr. Gurbanov. So we have one discussant, and that's another esteemed judge from Azerbaijan, Günel Hanım. Please, the floor is yours.
Thank you. I welcome all the participants and thank you for having me in this webinar. Azerbaijan's constitution grants citizens a right to a healthy environment, which forms a potential basis for the climate litigation. And now the courts worldwide are increasingly recognizing the link between the climate change and human rights, holding governments accountable for protecting fundamental rights such as health, weather, and adequate living conditions. As Mr. Gurbanov and you, Mr. Javid, Gadirov mentioned about the case of the European Court of Human Rights. And that's the reason the European Court of Human Rights stipulating to that case is that it's considering that the convention is a living instrument to be interpreted in the life of the present-day conditions. And as you know, the right to the healthy environment is not directly stipulated in the European Convention of Human Rights. And this because of the evaluative interpretation of various convention requirements has generally been progressive. And now today, the European Court of Human Rights accept the cases for the environment in the light of Article 8, respect of the family life. And the court has given clear confirmation that Article 8 of the Convention guarantees the right to a healthy environment. It found violation in the cases Lopez Ostra versus Spain and Guerra and others versus Italy. But I also want to mention about the other court's judgments. That is very important to see what's the practice of the not only the international courts, but also the courts of the states itself. For example, there's a case of Urgent Foundation where the claimant was Urgent Foundation. 900 Dutch citizens sued the Dutch government to require it to do more to prevent global climate change. And the court in The Hague ordered the Dutch state to limit greenhouse gas emissions to 25% below 1990 levels by 2020, finding the government's existing pledge to reduce emissions by 17% insufficient to meet the state's fair contribution toward the UN goal of keeping global temperature increases within 2 degrees Celsius of pre-industrial conditions. And this was the first decision by any court in the world ordering to limit greenhouse gas emissions for reasons other than statutory mandates. The other interesting case was the Mueller Defensive versus Shell. And that's this very interesting case where in its decision, the court ordered Shell to reduce emissions by a net 45% across both emissions from its own operations and emissions from the use of the oil it produces. The court made its decision provisionally enforceable, meaning Shell will be required to meet its reduction obligation even as the case is appealed. And still it is appealed, but still the court made its decision enforceable. And to the answer why Shell, the claimants answered that the Shell is one of the largest polluters in the world. Every year, the company emits 9 times more greenhouse gases than the entire Netherlands put together. And the court's verdict was that Shell reduced its emissions by 45% by 2030 compared to 2,900 figures. Shell is responsible for both corporate and consumer carbon dioxide emissions. The very important point is that but the corporate private law, the company itself responsible, not just the government. And also the court passage from the court's verdict was that the private companies also are mandated to respect human rights. And in case of the court practice in Azerbaijan, I must say that Azerbaijan does not have a robust tradition of climate litigation, but there's still a couple cases. For example, the cases on usage of the subsoil. For example, the claim for submit of active separation for mining and curing proposals, or the claims for inclusion in the list of the flood victims for the reparation of their houses, as the state compensates the damages caused by the flood. And about the standing point that for a climate case to be heard, plaintiffs must establish standing by showing a direct connection to harm posed by climate-related actions. It's important to point. And about the role of the courts, of course, the interpretation by the judge, by the court is very important. And what's the okay, I'm finalizing. And the very important point with the worldwide is now we're passing to the soft law requirements, and the growing consensus is often reflected through the development of soft law. And in the practice of the European Court of Human Rights, we see that now often the soft law requirements are implemented. Thank you for your time.
Very interesting passage. Actually, we're now passing to the next question, so it organically, so to speak, blends into the first one, and that would be the role of judiciary in adaptation measures from the human rights perspective. And I think our first speaker on this topic is going to be Sadiga Hanım. Sadiga Hanım, Professor Mehdiyeva, please. Welcome. For yours.
Thank you again. I will try to make my speech brief, and I will skip some parts that already mentioned by our colleagues. So, while we are usually discussing climate change and human rights, I often hear questions from my students and even from non-legal professionals, such as, why are human rights relevant to climate change? Why should climate change be viewed as through the lens of human rights law? Sometimes those kind of questions stem from confusion about the connection between environmental harm and human rights protection. I usually explain differences between theoretical and practical aspects of human rights and right to live in a healthy environment. The right to a healthy environment includes elements such as clean air, safety, biodiversity, and sustainable living conditions, but also it incorporates procedural rights, such as right to access to information, participate in decision-making, and seek justice for environmental harm. Human rights in environmental contexts generally refer to traditional rights, like the rights to life, health, and property, which are directly impacted by environmental harm. Historically, the right to live in a healthy environment has been recognized mostly by national constitutions and domestic laws. However, in 2022, UN General Assembly adopted, I would say, historically important resolution recognizing access to a clean, healthy, and sustainable environment as a universal human right. But still, there are a key distinction between human rights and between the right to a healthy environment. Human rights are primarily individual, while the right to a healthy environment also often has a collective dimension. But despite all these differences, both human rights and the right to a healthy environment plays a vital role for a legal framework for addressing environmental disputes, specifically climate-related claims. Also, I just want very briefly mention the current trends in climate debates and climate litigations. Well, we know that Paris Agreement required states to adopt effective measures for both mitigation and adaptation, and globally countries have outlined their emission reduction targets in their nationally determined contribution documents. However, situation shows, also experience shows that many states are slow to fully and effectively implement their commitments. In this context, climate claims brought by citizens, vulnerable groups, and other actors are becoming essential drivers of accountability. I just want to briefly mention one case which occurred in 2021 when the Supreme Court of Pakistan upheld the government notification barring the construction of new cement plants or expanding existing ones in environmentally fragile zone known as negative zones. The court emphasized that it's important to consider climate change in government decisions, particularly in impact on water sources. It also highlighted that there is a need for appropriate adaptation measures to secure water, food, and energy resources for the country. That kind of cases shows also helps not only citizens, also government to fulfill their obligation and kind of drive them. Also, I want to mention that there are differences between bringing climate litigation or the climate claims before courts between developed countries and developing countries. We should confess that it's generally a bit easier to bring such cases to court in developed countries. This is largely due to the stronger rule of law, established democratic institution, also high priority given to environmental protections in that countries. In developed countries, however, several challenges make it harder to bring climate claims. There's a strong focus on rapid economic development, limited personal institutional issues, and weaker democratic structures. And it can create barriers to filling those cases. Additionally, public awareness about climate rights is very often low. It's usually very low. For example, quite often floods or accidents caused by extreme weather are commonly viewed as acts of God without recognizing the role of human activities in causing those events or understanding their legal implications. And finally, I want to mention some aspects of the possibility bringing climate claims in Azerbaijan. Climate change is significantly affecting Azerbaijan, like especially for people in agriculture and those who living in coastal areas. Regions like Nakhchivan and Aran are experiencing severe losses due to drought, water shortage, and extreme weather. For example, in 2023, farmers in Nakhchivan harvested only 50% of their yearly crop, and the reason was climate-related situation and extreme weather conditions, also shortage of water. Urban areas also suffer in Azerbaijan from climate change, and a few weeks ago, heavy rain in Baku brought 3 months worth of precipitation in just one day, leading to a serious infrastructure damage and the tragic loss of 2 lives. This marked the first instance of human fatalities directly linked to the climate change in Azerbaijan. It was the first time when public discussions had focused on issue that how they should bear cost of repairing roads and vehicles damaged by the events. We know that under Azerbaijani law, Article 39 of Constitution provides a strong foundation for climate-related claims. This article guarantees everyone to live in a healthy environment, which gives access to clean water, air, and safety. It also ensures the right to access accurate environmental information, also to seek in compensation for health and property damage caused by environmental harm. Those guarantees are sufficient to support legal claims related to crop losses in rural areas or urban damage caused by climate change. I think that first climate-related cases in Azerbaijan courts will likely involve adaptation measures than mitigation, because Azerbaijan contributes only 0.1% to global emissions, but as a country, we are heavily impacted by climate change. And for us, adaptation is a crucial issue. Unfortunately, our national adaptation plan has yet to be approved, and it creates serious challenges for not only for citizens, also for local authorities, and it lays very serious groundwork for potential claims against the government. In the near future, I believe that climate claims in Azerbaijan courts will not only help restore citizens' rights, but also push the government to adopt flexible and effective adaptation measures. And I believe that this in turn could lead to the better governance and stimulate democratic and institutional development in country as well. Thank you for your attention. I'm open to the questions.
Thank you, Sadiga. You've already been also answering questions online, so appreciate it. Our next speaker on this matter is again Günel Hanım, Judge Sevdimaliyevadv, please.
Thank you again. Sadiga Khan mentioned about the UN General Assembly requesting advisory opinion. Oh, can you hear me?
Yes, I can hear you.
Okay.
I mentioned the resolution. Yeah, resolution.
Yes. I want to mention about that resolution, which it's a landmark moment in the history of the environmental law. And the ICJ, the European Court of Justice, has been tasked with answering two fundamental questions. First, what are the obligations of states under international law to ensure the protection of the climate change system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? So the first time that has come to their point, the right of the future generations, which is very important. The second, what are the general legal consequences under these legal obligations for states, whether they, by their acts or omissions, have caused significant harm to the climate change system or other parts of the environment? These questions are framed within the context of a wide range of sources, including the UN Charter, human rights covenants, environmental treaties, and customary international law. This comprehensive approach allows the court to consider the full spectrum of international law in formulating its opinion. The advisory opinion, once rendered, has the potential to reshape the landscape of international climate action in several ways. And addressing obligation towards present and future generations allows the court to break new ground, explicitly recognizing the right of future generations in international law. Most important, however, in the question on legal consequences for states that have caused significant harm to climate system. The court's answer to this question could pave the way for reparation for climate damages and enhance accountability. There are very many interesting cases, for example, about the adaptation and mitigation. For example, in Latin America, Colombia's constitutional court ruled that climate impacts such as flooding could force displacement, imposing on the state's obligation to support and restore displaced individuals' rights. These cases illustrate an evolving legal landscape where climate change is treated not only as an environmental issue, but also as a matter of human rights, expanding the way courts are holding government governments accountable globally. And in Pabay and Kabay versus Commonwealth of Australia, leaders from the Torres Strait Islands brought a claim against Australian government, arguing it had a duty to protect their communities from climate change. And we see more and more such kind of claims bringing by the small groups of vulnerable groups. And these cases asserted that the government must take reasonable steps based on the best available scene to mitigate the harm caused by rising sea levels and other climate impacts. I can mention about many cases, but in some cases we see that the international courts can take the step back. For example, in the Grand Chamber case of Hatton and others versus United Kingdom, you know that the case is the case of disturbance of the night-time regulatory regime of the Heathrow Airport, London. And in this case, for example, the European Court of Human Rights didn't find the violation of Article 8, just found the violation of Article 13, right to an effective remedy. The court decided the scope of review by the domestic courts was limited to the classic English public law concepts such as rationally, unlawfulness, and patent unreasonableness, and did not at the time allow consideration of whether the claimed increase in night flights on the scheme represented a justifiable limitation on the right to present for the private and family lives or homes of those who live in vicinity of the Heathrow Airport. So that was I also wanted to mention about this case because there were 5 dissenting opinions. It's a lot in the practice of the European Court of Human Rights that 5 judges were left their dissenting opinion with this judgment. So, thank you.
Thank you, Günel, for this amazing discussion. And we have another discussant on this topic. That's Mr. Bakhtiyar Mirzayev from Prosecution Office. And then we should be moving already to the third questions because we will run out of time. Bakhtiyar Bey, do you want to comment on this? Bakhtiyar Bey?
Do you hear me?
Yep.
I greet everyone.
Hello.
Really delighted to participate in this discussion.
Thank you.
Due to the time limitation, I will try to share my thoughts about this issue. And specifically, I will try to explore the prosecutor role in enforcing human rights within non-criminal proceedings related to climate adaptation. The Prosecutor Office is a constitutional institution in the Republic of Azerbaijan, as its primary functions are directly outlined in the Constitution of the Republic of Azerbaijan. And this constitutional status distinguishes the Prosecutor's Office from the other law enforcement agencies. While the Prosecutor's Office is a part of the judicial system, its role, unlike in some jurisdictions, is not solely focused on the defense of the accusation. In addition to representing the prosecution in the court, the Prosecutor's Office plays an active role in the criminal, administrative, and civil justice proceedings and serves as a key guarantor of human rights. In 2020, the significant reforms were implemented within the Prosecutor's Office of Azerbaijan, through which the Prosecutor's Office adopted the essential measures to promote a more dynamic and approach to the protection of human rights in society. These reforms also aimed at fostering broader acceptance of human rights principles. Thus, the Prosecutor's Office moved away from addressing individual rights violations on a case-by-case basis. Instead, adopted a broader systemic approach. Through the decree of the President of the Republic of Azerbaijan dated June 10, 2020, a new institution was established within the Prosecutor's Office to ensure the protection of public interests that affect society. This institution is the Department of Non-Criminal Proceedings. While the specific powers of this department are not discussed here, but it's responsible for the various areas, including the protection of minors' rights, the prevention of violence against women, safeguarding of parental rights, the widespread enforcement of labor rights and labor safety regulations, as well as participation in civil and commercial disputes, administrative violations, and other proceedings outside of the criminal prosecution. Additionally, preventing and combating environmental crimes constitutes one of the primary areas of focus for the prosecutor's office. It should be emphasized that the prosecutor's office does not focus on individual cases, but rather provides a unified approach to such offenses across the country. For instance, while the court resolves the specific cases, the prosecutor's office consolidates legislation and judicial experience, identifies the successful strategies, and applies them consistently throughout the Republic. And this approach is not limited to criminal prosecution or public prosecutions, but encompasses a broader range of legal matters, leading to more active involvement of the prosecutor's office in various fields of law. For example, in the investigation of criminal cases or related materials, the primary objective is not to impose penalties or punish individuals. Rather, the overarching goal is to eliminate the underlying causes and conditions that contribute to legal violations, and to take more comprehensive measures to prevent such violations in the future. Between 2020 and 2024, a total of 984 materials were investigated, 728 criminal cases were initiated. Additionally, 333 reports and 205 warrants were issued. These reports were sent to the central and local executive bodies, municipalities, and other relevant institutions as a part of the broader legal strategy. The purpose of these reports was not directed to punish any individual, but rather to promote more responsible practices in the use of water, air, and land resources, encourage educational initiatives and public awareness in these areas. Thank you for your attention.
Thanks a lot, Bakhtiyar. Thank you. We really appreciate your discussion of the role of the prosecutor office, in particular Department of Proceedings. So we should be moving to our third box question, I guess. So you have already moved to it, actually, in your discussion, and the question about responsibilities and liabilities of companies and private parties and corporations in mitigating and adapting to climate change. So it is my pleasure to present our first speaker for this question. That's Professor Labardini. Professor Labardini, the floor is yours.
Thank you very much, Javid. And thank you, my dear friend. Thank you very much on the Climate Law and Governance Initiative Secretariat as well. I'm delighted to be here participating in the Climate Law and Governance Day. This is quite an event, and I want also to thank you, Javid, because you put together a very comprehensive panel, 9 speakers in 70 minutes with questions. That's amazing. That's a big kudos for you. But getting back to the issue now. The one thing we have to always remember is that we know climate change is here, and we're living it. It's the consequences of several of us living in the past, and we have to find some kind of solution. First of all, we know about corporations, and they contribute definitely to climate change. Some of the panelists have also mentioned part of this, but we just good to remember 100 energy companies have been responsible for 71% of all industrial emissions since human-driven climate change was officially recognized. That's 41 public investor-owned companies, 16 private investor companies, 36 state-owned companies, 7 state producers, 100 companies for 71% of all industrial emissions. But this is not just the energy sector. It falls also into food and beverages. The top 15 US food and beverage companies generate nearly 630 million metric tons of greenhouse gases. These 15 companies produce more than Australia, which is the 15th largest emitter in the world. In 2022, the Philippines told us, and found the Human Rights Commission found out that 50 private corporations, carbon majors, are responsible for 21% of all global emissions emitted until 2010. So the only thing that we can say is the situation is dire. We have severe weather. Some of you mentioned right now, the rain. In 2011, there were 2 hurricanes coming, one from the Gulf and one coming from the Pacific, attacking. They got to Mexico, 2 million square kilometers. Essentially, all the country was under state of emergency. And Acapulco port, very beautiful, famous by movies and other parts, in one day fell the water that normally falls in 1 year. And furthermore, just going here by to the Caspian Sea, we must remember that while oceans are rising, the Caspian Sea is desiccating. So essentially, this means, for all practical purposes, that human rights change, climate change and human rights is truly a human rights emergency. Just as this was put out by the Inter-American Human Rights Commission in 2022, jointly with the Special Rapporteur on Economic, Social, and Cultural Environmental Rights. One thing that we have to keep in mind is that the law, for better or worse, has been rather slow on the issue. Because what is climate change and things? And that is not quite clear. We go to all the major declarations and treaties, and the issue was not there originally. It happened first. You had the Universal Declaration of Human Rights, talks about the slide thing, but then comes the American Rights Declaration, and there's nothing in there. Then we go on as well, furthermore, into the ICCPR, in the International Covenant on Civil Political Rights, nothing. In the Economic, Social, Cultural Rights, is just a minute reference talking about environmental hygiene. And then we go on, and it finally comes up that it was only until the 1970s that Constitution started saying this. And we have Spain, we have Peru, we have Portugal, and they're coming up with just the concept of a healthy environment. And that's when everything sort of starts rolling up. And properly said a little while ago was that the European Convention on Human Rights does not contemplate not even the right to health, let alone a healthy environment. The right to health was determined in 2017 with the case of Lopez de Souza. And that goes to one thing that we must ensure. The law needs to be moving forward as well, needs to be growing and putting itself up to date. And if it's not being done by itself, there will be some other mechanisms willing to come to it. Conventions are now, some of them coming up. Some of them more recent, for example, as in the Protocol of San Salvador to American Human Rights Convention, has the right, in Article 11, the right to a healthy environment, speaking clearly about it. Then we have to go even to the 2000s, the Charter Union. The African Charter has the right as well. The Arab Charter has one as well. And more in contemporary, the American Human Rights Convention on the Rights of the Elderly People from 2015 includes the right there again. This will soon be adapted when the UN adopts its own convention on this matter. So what I'm driving at with this is that even though the law has been slow to put up the concept of the healthy environment and who might be the culprit, courts are coming up to the fore. And we heard right now about several cases. We had a Mille Diffusen in Netherlands. We heard also about the, recently you mentioned this one itself, Verein Klimasinjurinen, Schweiz v. Switzerland. And what the courts are coming up is they're following the lines of what it is the concept of the human rights and a healthy environment itself. In Verein, for example, surprisingly, even though there was one corporation, the corporation, they have local standing to deal with the issue, to try to get the case of environmental damages to the environment. But the individuals were not. Right now, one of the previous speakers was talking about Hetten and others with UK into noise pollution. What happens, I guess, is that since the right to health is not clearly encompassed in the European Convention on Human Rights, the courts have been trying to adapt themselves. And they're showing themselves they're willing to it. It means the corporations themselves will also have to do with this. We have several declarations by the rapporteur, the UN rapporteur on independent issues on environmental, and it's saying that states, corporations, and businesses have to deal with this. So I foresee that this issue will be better treated in the future with a lot more worries for corporations, because the states will become liable as they start to become responsible or violating human rights in the international courts. And so they will start to regulate. Once they regulate, corporations will have to follow. Furthermore, corporations are doing this at the same time by themselves, because there's already talk by the UN of a treaty, a binding agreement linking also corporations. So everything seems to try to show that one thing is clear. Climate change is here. It was caused by all humanity. And now it's up to all humanity to solve this. And if the legislation or the treaty, the international domestic laws or international law is not quite up to the speed, then we will have to require other actors to come to the fore. And that is states, there's corporations themselves, but also the courts. The courts are now, without really saying that they're writing law, they're interpreting what they have available in order to try to deal with the issues we have to the front. Thank you very much.
Thank you so much, Professor Labardini. It was great pleasure and very interesting discussion. So we have another prosecutor from General Prosecutor's Office for Non-Criminal Proceedings, Kamran Bey. Kamran Bey, I will ask you to be as brief as you can, please, so that we can wrap.
I greet everyone. It's a pleasure to be part of this webinar, and considering the time limit, I will try to share my thoughts on a procedural approach to holding corporations accountable, administrative liability, and broader non-criminal proceedings related to systematic climate change issues as clear as possible. Azerbaijan's legal system is primarily based on the individual responsibility of natural persons, meaning criminal legal measures are applied to individuals who commit offenses. However, in our legal system, the liability of legal entities is primarily addressed in the context of corruption offenses and a limited number of environmental crimes. Environmental crimes, however, represent a broader issue that extends beyond individuals. Large construction companies, industrial enterprises, and major agricultural operations are also highly accountable in this context. These entities can significantly impact the environment, particularly in urban areas and on the outskirts of cities, disturbing the ecological balance. Therefore, ensuring corporate responsibility is crucial to preventing environmental crimes. And the primary objective of the Prosecutor's Office in this context is to hold not only natural persons, but also legal entities, companies, corporations accountable. Proper regulation and enforcement of corporate responsibility are key in this regard. Environmental crimes and corporate responsibility have become some of the most pressing issues of our time. Corporate responsibility extends beyond profit generation. It also involves ethical and legal obligations towards the environment and society. Environmental crimes refer to activities that cause harm to the environment and violate the law. These include air, water, and soil pollution, illegal resource extraction, destruction of biodiversity, and the improper management of waste. Corporations must adopt a fundamental approach to fulfill their environmental responsibilities. First, they must comply with environmental laws, strive to protect natural resources, and support the development of green technologies. At the same time, transparency and accountability are essential. Companies should enhance public relations by disclosing the environmental impact of their operations. Furthermore, companies must take measures to prevent harmful effects and avoid causing environmental damage. The legal consequences of corporate environmental responsibility are also significant importance. Companies that violate environmental law may face fines, suspension of operations, or be required to make compensation payments. Moreover, public pressure often compels companies to become more transparent and to operate in a more environmentally responsible manner. As a result, environmental crimes and corporate responsibility are closely interconnected. Companies must engage in sustainable and ethical practices, balancing profit generation with social and environmental accountability. This approach is both legally and ethically important and is expected to be more widely implemented in the future. If a company or corporation commits environmental violations, punitive measures should be imposed not only on individuals responsible, but also through monitoring the activities of the company itself. Such actions will serve as a deterrent and encourage other companies to exercise greater caution in the fight against climate change. And the Code of Administrative Offense of the Republic of Azerbaijan also recognizes the responsibility of legal entities. Under this framework, a legal entity can be held administratively liable for offenses committed by a group of individuals for the benefit of the entity or to protect its interests. This includes individuals who have the authority to represent a legal entity, make decisions on its behalf, or supervise its activities. As stipulated in Articles 18 of this code, liability may extend to officials who fail to exercise proper control within the entity. However, the imposition of administrative responsibility on the legal entity does not absolve the individual official responsible for the act or who participated in its commission from their personal administrative liability. The legislation on administrative offenses also prescribes more severe penalties for actions that harm the environment, such as illegal logging, pollution, and the destruction of water, air, and soil. Administrative sanctions imposed on legal entities include warnings, administrative fines, and the confiscation of objects used in the commission of the offense or those directly involved in the administrative violation. In recent years, practice of holding legal entities administratively liable has been established by the Prosecutor's Office. For instance, in 2024, administrative disciplinary measures were applied by the courts in cases initiated by the Non-Criminal Proceedings Department of the General Prosecutor's Office against legal entities for administrative offenses. And therefore, relying solely on state-led campaigns in the fight against climate change is insufficient. A robust legislative framework, effective enforcement mechanisms, active participation of law enforcement agencies, as well as the application of corporate responsibility and rigorous enforcement of penalties are all crucial. The state can achieve more substantial results not only through environmental campaigns, but also by taking decisive actions against individuals and legal entities that violate environmental laws. This comprehensive approach will help ensure ecological stability and create a healthier environment for future generations. There are significant issues in corporate governance. In Azerbaijan, at its core, corporate governance requires social responsibility, which must be embraced by society as a whole. The Prosecutor Office plays a key role in actively participating in this process. Traditionally, while the Prosecutor's Office has been seen as a body focused on criminal prosecution, but its role has evolved in response of changing societal needs. In today's context, the Prosecutor Office must go beyond merely prosecuting criminal offenses as much as such measures alone don't resolve the underlying issues. The harm caused by actions like illegal deforestation, soil degradation, and environmental destruction through mining is already done. In these cases, corrective measures cannot undo the damage. Therefore, a proactive approach is essential. While there is a need to strengthen criminal legislation by introducing more stringent sanctions and corrective measures cannot undo the damage. This new mechanism should focus on how to proactively reduce administrative bureaucracy and red tape. On the one hand, this will protect the rights of entrepreneurs, while on the other hand, it will encourage them to become more socially responsible and ensure the effective implementation of legislation at the appropriate level. Thank you for your attention.
Thank you so much, Kamran Bey. So we are nearly at the end of our discussions. I think in 5 minutes or so, the session will be collapse suddenly. So I would just like to give a couple of more minutes to our last discussant, and that's again Dr. Gurbanov, so maybe you can give us your view on the cases where corporations have been held responsible for environmental damage. So what is the judicial perspective on that? And on this, I will wrap up our today's
thank
panel.
you very much. Very briefly, I would like to say I completely agree with the previous speakers, with Professor Labardini and with Kamran, Aghayev, that we see that the main polluters, so the main players who polluted the ecology, who is playing this negative role, is the corporations, this is the government agencies or the private companies. What I would like to say that it's not like the Council of Europe, for example, in 1998, and the European Union, for example, in 2024, recommended to all member states to reinforce the criminal obligation for the any illegal actions in the field of the ecology. What I would like to say that there are many other aspects of such crimes, for example, transboundary crimes. We like the many countries face with the ecocide, ecocide crimes, and this notion now is very actual today during all these conferences and so on. What I would like to say that the next steps in Azerbaijan or outside Azerbaijan will be in the field of strengthening the responsibility of the legal entities, and not only legal entities, but also the persons who is responsible for such decisions in the governing bodies of these legal entities. And also it's very important to strengthen and to clearly define the requirements in the criminal code relating to this connection between the illegal actions of the legal entities and the results of such actions. For example, I know that in Azerbaijan, for example, because it was a topic of my scientific research, the problem is identifying these illegal actions and the effect of the legal entities in the ecological field, in the ecological crimes, because exactly of such a connection which is not clearly defined. So that's why we have many challenges faced in the future, and I do believe that together in joint attempts we will do all this, how to say, to achieve all the goals. I would like to thank the organizers for such important event, and look forward to participating in other meetings organized by the other universities. Thank you very much.
Thank you so much. Thank you to all discussants, attendees, speakers, participants. This was a really interesting, but I think we have basically run out of time completely. In 1 minute, the session will be over. So we won't be able, thanks to Sadiga once again for answering the questions in the live manner. So we had a discussion. So obviously, despite my very skeptical start on the role of the judiciary, we can see that the judicial branch will have to also adapt to the issues of mitigation, adaptation to climate change, and liability from the perspective of the environmental law. And in this regard, I hope that the legal community's attention to this matter and the conference of the parties 29, which is held in Azerbaijan right now, will also contribute to the global awareness, to the local awareness, and awareness among the local legal community to the issues of climate change mitigation, adaptation, and liability for the breaches of these legal issues, actually, for these legal rules and principles. Thank you once again. It was a great pleasure seeing you and meeting you. And I wish you good luck in your work and in your professional and academic endeavors. And thank you so much. So I think on this we can close our today's panel and say goodbye. Cheers.
Thank you. Thank you for managing.
Thank you.